interesting, landmark quality feature, is that, think for a second what was involved in Stromberg. She didn't say anything to get convicted, not words. What she did was raise a flag. And the court in the Stromberg decision considered the conduct of raising the flag to be speech protected by the First Amendment. And thus this was the origin of the symbolic speech doctrine, where conduct, not words, but conduct, that is expressive, conduct that conveys a message, will be considered within the freedom of speech under the First Amendment. And the symbolic speech cases have continued up to date from Stromberg. Stromberg was the first. Then in the 60s, during protests of the Vietnam War, young men, we all had to carry draft cards, having registered for the draft. And one of the protest manifestations of protest was to gather and burn draft cards to oppose the draft. And the government prosecuted people for doing that, and their convictions were upheld by the Supreme Court in the O'Brien case in 1968. But the court assumed that what the young men were doing in burning their draft cards was speech. It's just that the government interest in having the registration system work, keeping track of potential draftees, making the military induction process work, those interests outweighed the interest in being able to burn your draft card. Then there were the flag burning cases where the court threw out state and federal statutes that prohibited flag desecration by burning the flag. It was used, for example, during the Republican convention during the Reagan administration to protest the Reagan administration's policies, and the convictions were thrown out by the Supreme Court. Expressive conduct treated as speech. There was the cross burning case, an opinion by Justice Scalia, in which the court said that burning the cross can't be prohibited, at least if the law prohibits only burning the cross for a particular message, to get across a particular message. It has to be content neutral. And then the Bongitz case. In all these cases, these expressive conduct cases, these symbolic speech cases, the court is quite willing to decide that no words involved, no speech involved, is treated, they're treated as speech. Well, what happened to the clear and present danger test? As I said, it governed the subversive speech cases from Schenck all the way up into the 50s, and actually all the way until 1969, when the court decided the Brandenburg case. Clarence Brandenburg was a leader of the Ku Klux Klan in Cincinnati in the 60s, and he called up a television reporter from a Cincinnati station and told the reporter that the Klan was having a rally out on somebody's farm out in the county, and invited the television station to come cover the rally. So the reporter and a camera person went out and covered the rally, and there's these dozen or so guys in their white robes with the hoods on, the pointed hoods on them, and they say a whole bunch of racist stuff. Brandenburg made a little speech in which he said, "Personally, I believe the nigger should be returned to Africa, and the Jew returned to Israel," and threatens this. Says, we're not a revengeant organization. Revengeant is not a word. I hope you didn't put it in your papers. We're not a revengeant organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, I just noticed that there's a disagreement there between subject and verb. Our president, Congress, and our Supreme Court, that's plural, right, continues to suppress. Should be continue. I can't wait to get to these. Our president, our Congress, our Supreme Court continues to suppress the white Caucasian race. It's possible that there might have to be some revengeance taken. No such word. So Brandenburg is prosecuted under an Ohio law, same vintage, same general import as the California law that Yetta Stromberg was convicted under. And the Ohio law made it a crime to advocate the duty, necessity, or propriety of crime, violence, unlawful methods of terrorism as a means of accomplishing industrial or political reform. That's what these legislatures were aiming at, was squelching any movement, communist movement, to attain industrial, anti-capitalist, or political reform. So Brandenburg is convicted under this law and sentenced to prison, and his case goes to the Supreme Court, decided in 1969, and drawing a constitutional distinction between advocacy and incitement. This law, the Ohio law, prohibited advocacy of overthrow of the government or the use of crime or violence to attain political goals. And the court said that that is unconstitutional, that advocacy is protected. And the court says that the constitutional guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or of law violation, except where such advocacy is directed to inciting or producing imminent lawless action and is likely to produce such action. The mere abstract teaching of the moral propriety or even moral necessity for a resort to force is not the same as preparing a group for violent action and steeling it to such action. So that's news in 1969. That seems to have replaced the clear and present danger test for most of these subversive speech kinds of cases. The court has not, since Brandenburg, used the clear and present danger test. It has frequently used the Brandenburg test, drawing the distinction between advocacy and incitement. It's not perfectly obvious in all cases, which is which. I mean, clearly writing a book in which you espouse, it would be almost like Martin Luther King Jr., in which you espouse civil disobedience, the violation of the law, as a means of changing the rules in our country, that you can advocate that all you want. That clearly is not incitement to imminent lawless action. At the other extreme, I suppose, you can imagine somebody standing at the barricades with a torch in his hand and a mob behind him screaming, "Let's burn it down." That's probably incitement. In between, there's a lot of gray area. But the big dispute these days is over the imminence requirement, that the speech, in order to be suppressed, has to cause, be likely to cause, imminent violence, harm. And we'll consider some examples of that. The Brandenburg Rule that protects advocacy, subversive advocacy, unless it becomes incitement, is, in my view, one of the three pillars of our freedom of speech that the Supreme Court has erected. No other country that I know of protects advocacy of dangerous, hateful ideas, and lots of them explicitly prohibited. The other two pillars are, we'll come to next week, the Pentagon Papers case, the protection against government censorship in advance, prior restraints of what you want to say or publish, nearly complete protection against prior restraints, which is, if not unique to this country, certainly highly unusual in the rest of the world. And the third pillar is New York Times versus Sullivan, the right we all have to criticize government. Taken together, those three, Brandenburg, Sullivan, and Pentagon Papers, set us out there as having relatively extremely free speech and the press. But as I say, the controversy today is about the imminence part of the Brandenburg test. Even Anthony Lewis, for example, the former columnist and Supreme Court correspondent for the New York Times for many years, and a fervent true believer in the First Amendment, written 2 books on the First Amendment, great books, Make No Law, about New York Times versus Sullivan, and about the history of the First Amendment in this country, and Freedom for the Speech That We Loathe, which is more an essay about contemporary First Amendment issues. But in that book, in the Freedom for the Speech That We Loathe, a phrase, by the way, that comes straight out of Justice Oliver Wendell Holmes' opinion in When He Got Religion in United States versus Abrams. We grant freedom of speech for ideas that we loathe. Remarkable. Anyway, Lewis, in this second, the Loathe book, discusses some of the recent terrorist disasters around the globe, and those that he can attribute to speech. He says, like the subway bombings in London following a bunch of jihadist sermons in a mosque in London, like the ethnic genocide in Rwanda, where the radio incited the people to kill the other group. And he says, in these days, making an incendiary sermon to an audience that is ready to act ought to be imminent enough, and question whether the imminence requirement of Brandenburg is sufficiently protective of us in the terrorist era. The famous First Amendment scholar Alexander Michaeljohn, back in the 40s and early 50s, was something of a First Amendment absolutist about political speech. At one point he said, that's all the First Amendment is about, political speech, entertainment, movies, art, that stuff, that's not covered by the First Amendment. He came to qualify that in some ways. But in a remarkably courageous event, he went before Congress in the early 50s, during the height of McCarthyism and the anti-communist hysteria, and testified about what could be said and what the government could do about it. And he relied heavily, into this in the early 50s, anticipating the Brandenburg test. He relied heavily on the right that we all should have to advocate bad ideas. Incitement, on the other hand, would not be protected. And he said in his testimony, no belief or advocacy may be denied freedom if in the same situation opposing beliefs or advocacies are granted that freedom. If then, on any occasion in the United States, it's allowable to say that the Constitution is a good document, it's equally allowable in that situation to say that the Constitution is a bad document. Suppose these days, if you can say that Christianity is a good religion, you should be able to say, without worrying about the First Amendment, that Islam is a bad religion, and say it loudly. But Michaeljohn concluded that to be afraid of any idea is to be unfit for self-government. Well, what about today when we've got, today we don't have al-Awlaki anymore because he was killed by a drone in Yemen last year, one of those targeted killings. But al-Awlaki was an American citizen who went to Yemen, and his sermons were tremendously influential, available via the internet all over the world. And he was tough, defended the necessity, the moral necessity of attacking America. And he was also involved in actual terrorist plots. He advised the guy who went on a rampage in Fort Hood He got one of his students, or one of his students ended up trying to blow up the plane landing in Detroit a couple of years ago. What are we to do about those sermons that are available everywhere? Should they be suppressed? Aren't they like yelling fire in the theater? You might ask, is it practical to suppress those speeches? But there are other reasons why I think we have to let that go. I don't think that any single incendiary speech is the problem. I think it's more that the years of indoctrination into the ethos that terrorism is good, is necessary, that martyrdom is to be desired, training in madrasas, weapons training maybe in Pakistan or Yemen, and the audience for the sermons isn't set off by one sermon at all. How can you prohibit this one sermon? They're really there after years of preparation, or a lifetime of teaching that America is the enemy and should be destroyed if possible. And then you get to this video that the crackpot down in Southern California produced that came out last summer and was put up on YouTube, the Innocence of Muslims video. Have any of you seen it? Yeah, a couple? How'd you like the production value? I mean, this was really shabby. It starts out with some scenes of modern times, which are apparently scenes in Egypt of the Egyptian police, now under the new Muslim Brotherhood, going around and breaking down the doors of Coptic Christians and arresting them and hauling them off to prison. And then it flashes back a millennium and a half to do a sort of documentary of the Prophet Muhammad, showing somebody dressed up in what they thought he might have looked like. And it is uncomplimentary, to put it mildly, of the Prophet, showing him to be a homosexual, to be a womanizer as well, bloodthirsty, unprincipled, bad person. Production values, I mean, they shot it somewhere in a desert-like environment, and they show some horses coming across at one point in the foreground, you see all of these tire tracks, Jeeps and other vehicle tire tracks, sure, from a millennium and a half ago. Anyway, it's a terrible video. Stupid, offensive, racist, wrong, nuts. And its release on YouTube resulted in demonstrations in various places around the world, including Cairo, that resulted in the deaths of 49 people. At around the same time, a satirical French magazine called Charlie Hebdo, as in hebdomadaire, published a cover story making fun of Islam. The cover says, "Faut pas se moquer, don't make fun of us," the Muslim is saying to what appears to be a Jew pushing him around in a wheelchair. And then there are a bunch of really ugly, offensive cartoons purporting to be the Prophet Muhammad in various compromising, dirty joke kinds of poses. At around the same time, an American Jewish group sued to put up their signs on in the subway in New York. In any war between the civilized man and the savage, support the civilized man, support Israel, defeat jihad. They testified that by savage, they meant the Palestinians. Hate speech put up, and a federal judge ordered the city transportation agency to allow those signs to go up. Before that, there were the Danish cartoons, half a dozen years ago, where a little newspaper in Denmark had a cartoon contest in which they would satirize Islam and the Prophet Muhammad, and they did pictures. This was the most infamous of them, portraying the Prophet with a bomb in his turban. That set off demonstrations around the world, burning of the Danish embassy in various places, boycotts of Danish products, and several people killed. And then in this country, we've got this nutty guy down in Florida, Terry Jones, who organized the Burn a Koran Day. He rejected the appeals from the Secretary of Defense not to do it, and did it. All of these actions are, at a minimum, provocative. But they're different, aren't they, from urging an audience to go out and kill people? You're not talking about a captive audience. You're talking about YouTube, or the readers of satirical journals, or the general public in New York, the world at large. And none of these provocative kinds of speech had any immediate effect. For example, on the Innocence of Muslims video, that was posted in June of last year, and nothing happened. It was translated and